Hi, this is Richard Jacobs from myduiattorney.org, and I'm here today with Dale Naticchia, a criminal defense attorney out of Ohio in the Cleveland area. How you doing, Mr. Naticchia?
How are you doing?
Good, good. Thanks for taking the time today to do the interview. I really appreciate it.
Sure.
And if you're ready, we'll jump right into the questions.
Yeah, I'm ready now.
Okay. All right. First question is, what motivates you to be a criminal defense attorney, and why in particular do you work on a lot of DUI cases?
Well, in the 25 years I've been practicing, I practiced in a lot of different areas of law, including corporate law. Um, but I like things on an individual basis, and people that get involved in the criminal system have a real immediate need. And to do something good for them to help them through, they're very appreciative, and that motivates me. But OVIs, especially, and DUIs, as they call them, they're very good people that have never been involved with the system before. They either made a mistake of judgment, or the officers made a mistake of judgment, and they find themselves in a very bad situation. And I can help them out, and it always makes me feel good when they come out and they feel good about themselves and the result.
Okay. And over 25 years, how many DUI cases do you think you've handled?
How many?
Yeah, I mean, just a guesstimate.
On the average, my caseload for OVIs is about between 125 and 150 DUI cases a year for the past, say, 10 years.
Okay,
And
so
that's in all of Northeast Ohio.
also over 1,000 cases. That's a lot.
It is. And you have to have the proper staff to do these cases properly, because you have to be very detail oriented. There's a lot of things that go on with these cases, and they happen in a hurry. So I have a staff that knows what to ask and what to look for, and has all the courts and bailiffs on speed dial, so we can get things done quickly.
Huh. Okay. And also, what I hear with that many cases is obviously you know what you're doing. It's a lot of experience. So
Yeah, and it's as important to know the law as it is to know the people that are involved in the system, because one court might handle a case totally different than another court. Every prosecutor is different. Courts want to see different things. They have different procedures, and you have to be familiar with those procedures to effectively represent your client.
okay. So of the people that you see, is there any typical person? More men or women or first time people?
I would say between men and women, it's about a 50-50 split. Many times there are people that are involved in bad circumstances, like there's been a death in the family, or they're going through a nasty divorce. Something traumatic has happened in their lives that made them change their normal routine pattern that involves more drinking, and they make a mistake in judgment and end up in a bad situation.
Okay. And of the clients that you've had, are more of them close to the point oh 0.08 limit, or are they much higher?
Pardon?
Of the clients that you've had, are a lot of them close to the point oh 0.08 limit, or are their blood alcohol levels usually higher?
I would say the most normal that I see is between 0.102 and 0.15. Okay, which is, and the legal limit is 0.08. I get very few that are 0.08 or slightly above, and not that many over 0.20. But I would say between the 0.102 and the 0.15 range is mostly what I see.
And I guess just out of I guess fun, what's the highest BAC level you've ever seen of someone?
0.459 in Twinsburg, Ohio, in the afternoon. My client was leaving a swimming pool,
Wow.
a public swimming pool. The next
Okay.
day, he was starting rehab in Tennessee.
Huh. Okay.
So he was actually swimming.
Wow. So of the DUI cases you see, are there more due to drugs or more due to alcohol?
Mostly alcohol. It's not uncommon to get a case where, in fact, when the person is arrested, they do a search of the car and they come up with paraphernalia or marijuana. Uh, Testing for drugs, in Ohio, there are levels for certain drugs in your system,
Mm.
including marijuana, uh, marijuana, it's 10 nanograms to 1 milliliter of urine. They have to do a urine or blood test. That's a very, very low level. And in marijuana, the marijuana metabolite stays in your system for approximately 28 days. So it could have a cumulative effect, and you might not have smoked for 2 days. They stopped and believed you're impaired. Do a urine analysis and find out that you are over the legal limit for marijuana.
And they'll still charge you with a DUI?
Absolutely. And it's becoming more common that I see prescription drugs. That's mostly what I see. And even though you're taking the drug as prescribed by the pharmacist, if you're under the influence or impaired, and the officer can say he was acting sleepy, it didn't seem like he knew what he was doing, you will be charged with an OVI. And I've had many cases of where people were taking drugs such as Soma or Xanax in the prescribed dosage, and they ended up being charged.
Well, I mean, it may be hard to say in general, but with those kind of cases, is it harder to defend them? Do they usually have bad outcomes or good ones? Or
It's different to defend them uh, because you've got a person that, first of all, has admitted to taking the drug. So the issue becomes: is that person impaired? Unfortunately, all you're stuck with the officer's testimony. That's going to say, well, he looked like this. He reacted. This reaction time was slow. And the way to counter that is you get the video, you get the booking video, you get the dash cam video to counter what the officer is saying about the client. And it's certainly a mitigating factor where a client has been taking medicine as prescribed, and no one has warned him or her that such could impair their ability to drive. And in fact, many times that is the case.
well, how about in a circumstance where you were talking about marijuana? If I don't know, someone hadn't smoked it in a week, and they were pulled over, and they were arrested for they were tested, arrested for DUI. In that case, is it any easier or still just the same?
Um, it is, well, basically, anytime you have a lab test, you have more issues. Everything has to be handled. There's a chain of custody that has to be established, and it has to be handled in a very specific fashion as it's determined by the Ohio Department of Health. And the prosecution bears a burden to show that all those rigorous procedures have been followed. So anytime there's a blood or a urine test involved, whether it be alcohol or drugs, it opens up the doors to a lot of defenses, and many times I'm able to keep the tests out of evidence, which gives the prosecution very little to go on.
Hmm. But I don't mean to keep pushing on this, but I'm just curious if the test was admitted, and again, let's say if it was marijuana and it was, I don't know, the person. Well, I guess it depends on what the person says. If they said they hadn't done anything in 10 days, could they prove impairment? I don't know
Right.
if you
Well,
can speak.
this is the trick bag with the per se level. It's just presumed, and it's an irrebuttable presumption at law that you are impaired if you're over a particular limit. That's what makes all these cases so difficult. You have to start chopping away at the prosecution's case from the first day. Once if they have a good result that says that you're over the legal limit, you're guilty.
Wow.
And that's what makes OVI different. Is it's the only crime I know where there's actually a guilty machine. You blow into the machine and you're guilty.
Huh. Okay.